There is a date that should have ended this story before it really began. May 13th, 2026. On that day, an Alberta Court of King's Bench justice named Shaina Leonard issued a ruling that should have settled, as a matter of law, the central question hanging over the province's independence movement. The ruling held that a unilateral path to Alberta independence would violate the constitutionally protected treaty rights of First Nations within the province. Not might violate, would violate. The court did not leave room for ambiguity. 6 weeks later, on June 19th, separatist groups gathered in a hotel in Calgary and formally launched a campaign called Let Alberta Decide. And Premier Danielle Smith, fully aware of the ruling that had been issued against her government's legal position just weeks earlier, proceeded to add a constitutional independence question to a 10-question provincial referendum scheduled for October 19th. Most coverage treated the court ruling and the referendum launch as two separate news items on two separate news days. They are not separate. They are the same story, told in two different registers. One register is legal, where the question has already been answered. The other is political, where the question is being asked anyway, in defiance of the answer. Over the next few minutes, I'm going to show you why that gap between the legal floor and the political ceiling is the most consequential fault line in Canadian federalism right now, and why it has already produced a treason accusation against a sitting premier. Here's what you need to understand first, because the legal architecture is the whole story. Alberta's relationship to the rest of Canada is not governed by a single constitutional document that treats the province as a simple administrative unit. It is layered with the Numbered Treaties, a series of agreements signed between First Nations and the Crown in the 1800s and early 1900s, through which Indigenous nations ceded certain rights to land in exchange for specific, enduring commitments from the Crown. These treaties were signed not with the Government of Canada as a corporate entity, but with the British monarchy directly. That distinction matters enormously for what comes next, because it means First Nations within Alberta have a treaty relationship that exists independently of and prior to the province's relationship with the federal government of Canada. Alberta cannot simply vote itself out of Confederation and assume the treaties travel with it, or disappear, or become Ottawa's problem to sort out later. The treaty relationship is with the Crown. It is constitutionally entrenched, and the Alberta Court of King's Bench has now formally ruled that any unilateral move toward independence would violate it. That is the official legal position as of May 13th. Here is the operational political reality that followed it. Danielle Smith's government did not abandon the independence question. It added it to the referendum anyway. 10 questions on the ballot in October, and among them, a constitutional question on independence that a court in her own province has already found legally untenable as a unilateral process. Think about what that decision actually represents. It is not a legal argument that the ruling was wrong. Smith's government has not, at least publicly, mounted a serious case that Justice Leonard misapplied the law. It is a political decision to proceed with a question whose legal viability has already been challenged successfully, betting that the political value of asking it outweighs the legal reality of what happens if voters answer yes. This is where the story stops being abstract and starts being concrete, because the reaction from Indigenous leadership in Alberta was immediate and severe. On June 17th, First Nations leaders called for Smith to be investigated for treason. That is not a word used casually in Canadian political discourse. Treason is among the most serious accusations a citizen can level against a head of government, and it was not deployed metaphorically. The argument behind it is straightforward and, given the court ruling, legally grounded. If a sitting premier knowingly proceeds with a referendum process that a court has ruled would violate constitutionally protected treaty rights, the leaders making this accusation argue that the Premier is acting against the constitutional order she is sworn to uphold. Whether or not a treason investigation ever proceeds through any formal channel, the fact that the accusation was made publicly by recognized Indigenous leadership tells you how seriously the treaty rights community is treating Smith's decision to proceed. Now look at the case the separatists are actually making, because understanding their argument is necessary to understanding why this movement has momentum despite the legal obstacle in front of it. The co-chairs of the Let Alberta Decide campaign, separatist lawyer Keith Wilson and farmer Tanya Clemens, are making an economic argument. Alberta, in their telling, possesses the labor force, the agricultural capacity, and the energy resources to function as an independent state. This is not a fringe argument made without material basis. Alberta's energy sector remains one of the largest oil and gas producing regions in North America. Its agricultural output is substantial. Its population, while smaller than Canada's largest provinces, is economically productive on a per capita basis that exceeds the national average. The separatist case is not built on grievance alone. It is built on a calculation that Alberta contributes more to Confederation than it receives back, and that independence would allow the province to capture the full value of its own resource base without federal equalization payments, federal regulatory friction, or federal energy policy that the province's conservative base widely views as hostile to its core industries. That economic argument exists in genuine tension with the legal one, and neither side has fully reckoned with the other in public debate. The separatists are arguing economics. The court has already ruled on the law, and the gap between those two conversations is precisely where Smith has chosen to place her referendum question, deliberately or not. Here is where the two threads of this story converge in a way that should concern anyone watching Canadian federalism right now. The treaty rights ruling is not simply a legal technicality that separatists can root around with better lawyers or a different process. It reflects a structural reality about how Confederation was built. Alberta did not enter Confederation as a blank territorial slate. It entered with First Nations already present, already governed by treaty relationships with the Crown that predate the province's own existence as a political entity. Any serious path to Alberta independence would require resolving what happens to those treaty obligations. And the court has now said clearly that a unilateral provincial process cannot simply resolve that question by ignoring it. The separatist movement's economic case, however compelling on its own terms, does not currently include an answer to this legal obstacle. It proceeds as though the obstacle does not exist, or as though it can be negotiated away after a referendum produces a mandate, rather than before. And this is where the human texture of the conflict becomes impossible to ignore. This is not playing out only in courtrooms and legislative chambers. It is playing out in small Alberta towns where neighbors are now openly divided. In Sundra, a traditional rodeo parade, a community event with decades of history, was canceled after threats emerged over floats carrying independence flags. Think about what it means for a rodeo parade, of all things, to become a flashpoint serious enough to warrant cancellation over safety concerns. In Tabor, official orders to remove pro-separatist signage were met with civil disobedience, residents simply refusing to comply, daring the local authority to enforce a removal that a significant portion of the community does not accept as legitimate. These are not abstractions. They are small towns where the constitutional crisis has become a visible, daily, neighbor-to-neighbor reality. Now consider the position this places federal conservative leader Pierre Poilievre in, because his predicament illustrates exactly how this referendum is reshaping politics well beyond Alberta's borders. Poilievre is Alberta-born. He has spent his career building a political identity around Western Canadian grievance against federal liberal governance, against energy policy he characterizes as hostile to the province, against a political culture he argues looks down on the resource economy that sustains much of his home province. That positioning has been central to his political brand for years. But Poilievre also leads a federal party whose entire institutional purpose is to win power in Ottawa and govern the country as a whole, which means he cannot credibly endorse a movement aimed at breaking the country apart. On June 8th, in a speech in Calgary, he made his position explicit. Alberta's path forward should run through replacing the federal government at the ballot box, not through independence. That is a coherent position. It is also a position that satisfies almost nobody on the separatist side of his own provincial base, the voters who are organizing rallies, launching campaigns, and in some cases, calling for treason investigations against their own premier for not going far enough. Poilievre is trying to hold together a coalition that wants two incompatible things: full-throated support for Western grievance and a federal leader who can win a national election that requires votes far outside Alberta. The standard has changed here in a way that deserves to be stated plainly. For most of Canada's history since the 1995 Quebec referendum, the conventional wisdom was that Quebec represented the country's primary existential fault line, and that Western alienation, while real, expressed itself through federal elections and resource policy disputes, rather than through formal independence referenda. That assumption no longer holds cleanly. Alberta now has a sitting premier proceeding with a constitutional independence question that her own province's court has ruled legally untenable. In the same political season that Quebec's own provincial election campaign is being led in the polls by a sovereigntist party. Two separatist pressures, operating on different legal and cultural logic, are building simultaneously. And in Alberta's case specifically, the obstacle is not just political resistance from Ottawa. It is a constitutional treaty relationship with First Nations that exists independently of the province-federal relationship altogether, one that the courts have already weighed in on and found dispositive. What comes next is the question neither side has fully answered. The referendum proceeds on October 19th, regardless of the May ruling, because a referendum question and a court's assessment of its constitutional viability are not the same instrument. And Smith's government has made the political calculation that asking the question carries value, even if acting on a yes vote would run directly into the treaty rights wall the court has already identified. If the referendum passes the independence question, Alberta will face a choice between proceeding down a path the court has already ruled unconstitutional, which would trigger an immediate and serious legal confrontation with First Nations and the federal government, or treating the vote as symbolic leverage, a mandate to extract concessions from Ottawa on energy policy, equalization, or regulatory authority without actually pursuing secession. That second outcome, a referendum used as leverage rather than a genuine secession process, is the most likely resolution given the legal landscape Justice Leonard's ruling has established. But leverage strategies carry their own risks. Once a premier has put an independence question on a ballot and watched a portion of her own base organize around treason accusations and parade cancellations, the political energy generated does not simply evaporate if the government quietly treats the result as a negotiating chip rather than a mandate. The separatist movement, having been legitimized by its inclusion on an official ballot, will expect the premier who put it there to act on it, regardless of what the courts have said about whether she legally can. Watch two things between now and October. First, watch whether Smith's government articulates any legal theory for reconciling the referendum question with the May ruling, because right now, that reconciliation simply does not exist in the public record. Second, watch what First Nations leadership does if the independence question passes, because the treaty rights claim that produced the May ruling does not require Alberta's cooperation to be enforced. It can be pursued through the courts regardless of how the province votes, which means a yes vote in October would not open a path to independence. It would open a direct legal confrontation that the province has already lost once before the vote even happened. A referendum is a measure of political will, A court ruling is a measure of legal reality. Alberta is about to find out, in front of the entire country, how much political will it takes to override a legal reality that has already been settled. And what happens to a province, and to the leader who put the question on the ballot, when the answer turns out to be not enough? If this story is telling you something you have not heard elsewhere, share it. Drop your thoughts in the comments. I want to hear it. Like the video if you want more of this, and I will see you in the next.